everyone. We're going to go ahead and get started. Thank you for joining us today and taking time out of your busy day. I'm Jenna Kirsten, your moderator for today's webinar. I'd like to welcome you to this session on privacy versus security. I think it's going to be a great topic today. Let's go over a few things before we dive into our discussion. All attendees will be muted throughout the session, but we do encourage you to ask questions using the Q&A feature located in the GoToWebinar toolbar. I'll monitor those throughout the hour, and we'll have some time reserved at the end to answer those. This session is also being recorded, and all attendees will receive a link to the recording, as well as a copy of the slides in your inbox. Just a little bit of background about who we are before we get started. KirkpatrickPrice is a licensed CPA firm in PCI USA, providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer a wide variety of information security services such as audits, pen testing, plus readiness and guidance on frameworks like SOC 1, SOC 2, SOC for cybersecurity, PCI, HIPAA, HITRUST, GDPR, FISMA, and ISO 27001. We also encourage you to connect with us by subscribing to our blog, visiting our library of recorded webinars. You can catch up on any series at any time, and following us on LinkedIn, Twitter, and Facebook. Now I'd like to introduce you to today's speaker, Mark Heinley. If you join us for any of our webinars, Mark is on here a lot, and you guys know that he is an expert on GDPR and privacy at KirkpatrickPrice, so we're happy to have him today. Welcome, Mark.
Thank you, Jenna, and thank you to the rest of you for joining us today as we talk through the difference between privacy and security. Before we begin, I need to give our regular disclaimer that this session is for informational purposes only, and it's not intended to be legal advice. If you do need legal advice, we recommend that you talk to your own attorney. So let's get into today's session. We're going to talk about the differences between privacy and security. First, we're just going to talk about why this is a subject that's even worth spending some time on, and I think it is worth spending some time on. Secondly, we'll spend some time talking about the philosophy of privacy and security, and some general different approaches to privacy and security. Talk through some sort of older approaches to privacy and security and what I think is a newer and more accurate approach to privacy in particular. Then we'll talk through some key components of some specifics where we can actually look at concepts where privacy and security might be different, but in some cases might have united goals. And we'll talk about what happens when people don't know the difference between privacy and security, and then rainbows and unicorns is what we mean when we say people understand the difference and they're able to achieve both privacy and security. All the good things happen when we know and accomplish privacy and security. So first, let's just talk about why we're talking about this topic, the difference between privacy and security. Organizations in general want assurance of regulatory compliance, and they often come to our firm to ask us for help in establishing and achieving regulatory compliance. And typically what they do is they offer evidence of their security efforts in order to demonstrate their compliance. So for example, we'll be talking about GDPR on a sales call or just an inquiry, and they'll say, well, we have encryption. So is there anything else we need to do to be GDPR compliant? Or we'll begin an engagement with a client about GDPR compliance, and they'll say, okay, we'll need to make sure we have you talk to our development team. And while that's certainly helpful if application development is going on, that's not really the starting place for a data privacy engagement. So knowingly or unknowingly, I think what we often find is organizations and individuals are saying there's really no difference between privacy and security. So that's one reason we're talking about it, is because people sometimes think there isn't a difference between the two. And then secondly, I just think there is a general bent and bias, not necessarily in a bad way, but just in a historic way towards information security. I think if you were to to Google search the terms information security and information privacy, you're going to typically get more hits and more recognition around information security terms. There's really not an information privacy sector like there is information security. I mean, even our firm started based on a need in the information security space. So we come from that background. And then last summer, just as a way of further evidence outside of myself or our firm, there was an article from the Brookings Institute by an individual named Cameron Carey, and he was referring to the current situation in the U.S., but I think it applies worldwide. He said if things don't change from a legal perspective, this is the quote. He said, "More and more data about each of us is being generated faster and faster from more and more devices, and we can't keep up. It's a losing game for both individuals and our legal system. If we don't change the rules of the game soon, it will turn into a losing game for our economy and society." That's not a very optimistic or encouraging approach to data privacy, but I think that's a perspective that's shared by other individuals in positions of power and within organizations. And so I wonder if organizations not only say there's really no difference between information security and information privacy, but if they also might say there's really no benefit to working on data privacy or information privacy because it's really not possible to achieve that goal. And so we're just going to spend our time focusing on security. And so the purpose of this presentation is really to educate, empower, and inspire to greater levels of data privacy. That educate, empower, and inspire trifecta is part of our company's mission and values. So not only do we seek that when we're performing services for our clients, but we also include that goal for our webinars. And I think a reasonable level of data privacy is achievable. So that reasonable level of data privacy it starts with understanding what data privacy is. So let's talk about sort of philosophy of data privacy and data security. This is high level stuff. This isn't just specific legal requirements, but this is just the perspective of why these concepts exist and what they mean to different people. So, from a historical perspective, on the information security side, technology developed. We thought it was great, and then bad things happened with that technology because of people who were accessing technology who shouldn't have access. There was, theft and breaches and hacks, and we said there's a greater need to be secure. And then privacy developed, security developed, and we thought it was great. But then bad things happened with information by people that we gave the information to, and so there was a need to figure out what to do with information privacy. One author used what I think is kind of the older view of privacy and security. He said privacy and security are like parts of a window. Windows allow access in and out of a building, and they also allow you to see what's inside and what's outside. They allow a sense of transparency. And so he said, if you think about information and privacy and security like the concepts of a window, then we can sort of understand the concepts of security and privacy and the differences between the two. So Windows allowing access is great, but sometimes we don't want to allow access. So we create security measures like metal bars on a window, and those restrict the access inside and outside of the building. And that's evidence from this sort of older perspective about information privacy and information security. That's example of information security. I still think that's pretty accurate. But even if you put bars on a window, you can still see through to what's inside. So we say, okay, security is good, but we need more because it's not just protecting what's inside, but we also want to sort of obscure or keep what's inside hidden from those outside. So we create privacy. Shades or blinds on a window, for example, are ways that we create privacy. So I think that perspective is partially correct, but I think it's not totally correct. I don't think privacy is just about keeping what's inside hidden or obscured. But I know this author's perspective is shared even at a sort of a U.S. federal government level. I've got a quote from a website called HIV.gov. This is a U.S. government website around sexually transmitted diseases, and it talks about the need, which is legitimate, for information security and privacy when you're dealing with sensitive healthcare information. And this was the difference. This was the defining approach to privacy and security that this website includes. It says security is about safeguarding data, whereas privacy is about safeguarding user identity. Again, that just evidence, I think, of a certain perspective on what used to be or has been, and may still be, an approach to the difference between privacy and security. But I don't think those sort of window bar examples and analogy and philosophy is entirely correct. I think the newer approach to privacy in particular, information security is still about, the goal of it is it's important to protect data. But information privacy, I think the goal is now it's important to control data, not just to obscure the identity of whose data it is, but allow certain controls around those data. And that control is divided between organizations and the people who the data belongs to, data subjects, to use the term of GDPR, or consumers, to use a more common, more broad term. And that control not only is divided between the organization and the user or the data subject, but it's based on data subject rights and organizational responsibilities. So, for example, if you go to the first page of the text of GDPR, and we've got just a screenshot of what that looks like so that you can validate that what I'm saying is true. If you see, this is from the first page of the text of the law. That paragraph 1 says that the protection of natural persons related to processing their data is a fundamental right. This isn't just about obscuring who they are, their identity, but it's about a fundamental right. It's a much more deep concept to that. So in contrast to sort of that window analogy and that HIV.gov perspective, data privacy is about, in terms of the newer approach, data privacy is about control that stems from fundamental rights. So that's, I think the philosophy behind what I would use when we're approaching data privacy is it's about control. I think it's important to take that philosophy and make it concrete. So we're going to look at some key components of privacy and security, really more around privacy, but security plays a role. And we've got 7 different components here: scope, particularity or uniqueness, disclosures, access, data usage and third-party transfers, minimization and retention. And we're going to go through each of these 7 different components and try to demonstrate the difference between privacy and security when it comes to each of these components. And these components, from my perspective, apply regardless of what regulatory or security or industry framework you're talking about. These are concepts that you can use regardless of what industry or framework you're using. So let's start with scope as the first key component. From an information security perspective, scope tends to apply to all information assets that an organization has: trade secrets, operational reports, financial information. And typically at an organization that's developed some level of information security maturity, that information is classified. There's an information or data classification policy that says, breaks down data into a couple of different groups, public or common data, sensitive, confidential, proprietary, a couple of those different terms that are used. But all data falls into one of those buckets, and then there are security controls applied to those different groups of data. So any piece of data that an organization holds, there's some level of security that's applied to that data. On the other hand, privacy tends to apply to information provided only by data subjects or consumers, things like names, email addresses, payment information. The privacy requirements, whatever it is, whether it's contractual or legal or regulatory, govern things that have come from outside, whether it's directly from the data subject or consumer, or via third party who obtain that information from a data subject or consumer. And so there's a much more narrow scope. So when we're talking about privacy and security requirements, the key takeaway from this component is just to note that there's an important, high importance in defining what information is covered by privacy requirements, because not all information at your organization is going to be subject to the things we're going to talk about in the rest, these other 6 key components. And it's important you don't want to disclose things you don't have to disclose. You don't want to disclose trade secrets if you don't have to. You don't want to disclose operational information if you don't have to. On the other hand, the risk of sanctions and loss of business and loss of reputation if you don't disclose the things that you're required to disclose. So the first key component where we see a difference between security and privacy is scope. Security tends to apply to all information assets, and privacy tends to apply to only information provided by those outside the organization, data subjects and consumers. The next key component that's going to serve as an example for our discussion about privacy and security is, I just called it particularity or uniqueness for lack of a industry standard term or a concept that I've seen from others. And the goal here is to demonstrate that from my exposure to information security frameworks and requirements, that from a security perspective, there are generally acceptable security standards that tend to cross multiple privacy disciplines. So you could use AES 256 encryption for GDPR and for HIPAA and for certain consumer financial protection laws. There's not a encryption standard that's set out in any of those requirements. Antivirus or anti-malware tools and resources could be acceptable across multiple privacy disciplines. You don't necessarily have to change your antivirus if you were subject to HIPAA and now you're also subject to GDPR. Control like multi-factor authentication could apply across multiple privacy disciplines. So those are things that can be fairly standard and can stay the same if they're appropriate across as a company adds new products or services, or as new security privacy laws come out. On the other hand, privacy tends to be a lot more particular in terms of the requirements and data types. So for example, GDPR has a requirement for something called a designated representative. That means if you're not based in the EU, or you don't have an office or an employee or sort of presence in the EU that way, then you have to go out and find someone, either place someone there that's within your organization, or contract for someone outside your organization to represent you in the EU. That's not a requirement for other data privacy laws. The California Consumer Privacy Law that's coming into play in the beginning of 2020 allows a private right of action for breaches. So if you're subject to that law and you have a breach, there's a possibility that someone who's been affected by that breach could sue you for monetary damages. But GDPR doesn't have that requirement or that element. And then HIPAA has a requirement to account for disclosures of information of certain kinds that are very particular, dates and times and people, whereas other laws don't have that kind of requirement. They might have a general requirement that says, we share we share information with third parties related to information security or data storage or analytics, but it doesn't necessarily require certain specific dates and times to be recorded and disclosed to a data subject. And then there's also data types that are particular. So GDPR has what's called special categories of data that includes things like race and healthcare information. And then FCRA is a law in the United States that applies to the use and disclosure of credit information from a credit bureau, whereas COPPA applies to the data of children. So you not only have laws that have particular requirements that are different from each other in the laws, but also there's different requirements based on the type of information and data that you're trying to control. So, and then if that weren't enough, there's also contracts that are unique to clients and customers and privacy policy commitments that differ from one company to the next. And so all those different privacy dynamics could all use multi-factor authentication, but there's going to be a lot of different dynamics in terms of the disclosures and requirements within certain privacy laws. So this one may seem obvious, but we find a lot of organizations who don't know what regulatory and contractual privacy requirements apply and which don't. They're sort of scrambling either because they don't have resources or they don't have time or they just don't have information, or they've got expectations from third parties, clients, existing or potential clients who are saying, you need to apply these certain controls under their security or privacy. But sometimes those controls aren't appropriate or aren't required to meet certain standards. So it's important to know what regulatory and contractual privacy requirements actually apply, and to know the difference between which privacy requirements apply to certain data sets that you may have and which privacy requirements apply to other data sets, because the requirements may not be the same. Next, we'll talk about disclosures. And this is a particularly a requirement that's specific and exclusive, essentially, from my perspective, to privacy. There really aren't any security disclosures that are required that I know of. There are some privacy laws that require disclosures about security, but then it's a privacy disclosure. For example, GDPR requires certain disclosures about efforts to safeguard data. Those should be included in something like a privacy policy, but that's a data privacy law that requires it, not really a data security requirement. And from a privacy perspective, there's endless disclosures. For example, GDPR also requires international data disclosures about international data transfers and the mechanisms you use to safeguard data when you're transferring data outside of the EU. GLBA requires annual privacy notices, and the California Consumer Privacy Law requires a disclosure of an opt-out option in terms of allowing consumers to opt out of their data being sold or shared. And one thing in particular I want to note is that your privacy policy needs to include required disclosure, but it can also create requirements for data use. So I've got 3 examples of requirements that come from laws, but you can also create standards for control by including a commitment to something in your privacy policy that's not necessarily required by law. There are organizations inside of the U.S. where we're based and where I'm based, although we have clients all over the world, who have been sanctioned by the federal government for commitments they made in the privacy policy that they didn't uphold. For example, an organization that gets fined over $10 million because they made a commitment to consumers in its privacy policy that didn't share data with third parties in certain circumstances, and that wasn't true. The organization was sharing all kinds of personal data with third parties. So simply putting that statement in the privacy policy was what triggered the compliance risk, even though there wasn't a requirement for that organization could have shared data with third parties. It just, when it said it didn't, it was there. It created a requirement for itself. So be careful to review your privacy policy and make sure that you're actually committing to things that are both required from outside sources, but that you're also consistent with what you're actually doing internally as an organization when you have some discretion. The next key component is about access. And this is an area where there's concepts for both security and privacy. From my perspective, access on the security side is about technological tools to restrict access from an internal perspective, but also an external perspective, trying to limit it appropriately in both cases, internally and externally. So you have things like Active Directory and physical security controls like biometric readers. You've got access logs and access reviews where you're checking to see who has access to what information and whether they should have that access, whether it's right, and whether they should still have it. Those are things that are typically done on the security side. On the privacy side, it's not so much about the technology. In fact, it's really about the regulatory or contractual requirements to restrict and grant access. It's basically asking the question from an internal and external perspective, who actually needs access to information? So from a security side, there's generally a consensus with, sort of things like role-based access. But you could end up with roles that don't, from a security perspective, that are granted access, and that's consistent with the security requirements. But from a privacy standpoint, those roles don't actually need access to data. And so you may be violating a privacy requirement from a regulatory or contractual perspective, but consistent with a security perspective because the right privacy standard hasn't been applied. So from a privacy perspective, when we talk about access, we're talking about, does someone within an organization, even if they are an active employee who's undergone information security training, they've passed the background check, there's been a defined documented process to request and grant them access based on their role. They may log in using multi-factor authentication, and they may have a VPN and follow everything from a security perspective correctly, but their role may not actually require any access to personal data in order for them to complete the task that they're required to complete as part of their responsibilities in their job. So in that case, you would have security, but not privacy. Another challenge when you're talking about access is that you might have tension between, and this is our takeaway for the concept of access, you might have tension between security access and privacy access, especially from an external perspective. From a security perspective, you'd probably want to restrict access to anyone outside of an organization. But from a privacy perspective, there are certain laws that require you to grant access to data. HIPAA and GDPR, for example, both require you to give third parties access to data. That doesn't necessarily mean you have to allow them, you don't have to create a portal or anything like that, but there still needs to be some way in which data that is secured within an organization has to be disclosed in some manner. So there can be tension between the privacy requirement to disclose or to provide access and the security need to protect that data. So it's important to have individuals from different parts of an organization to share their perspectives and what's needed in order to come up with systems that work to grant access within the expected timeframes without unnecessarily exposing information. Data usage and third-party transfers, I kind of lump these two different items into one because the concepts are kind of the same. From a security perspective, there's a concern for internal rules consistency and just making sure that transfers to third parties are secure. For example, you're thinking about methods such as FTP and encrypted email and VPN. On the privacy side, this is similar to the concept of access. We're concerned with the purpose of data use and the permissibility of transfer of personal data to a third party. So data usage is not universally provided when an organization obtains the name, email address, healthcare information, et cetera, from an individual. Their privacy says that there are limited permissible uses within the organization, and that means limited permissible uses in terms of transfers. So if you've got consent as a permission to use data, then you're only allowed to use that data on the privacy side for the reasons that the individual gave consent to. As GDPR has become effective and more organizations are moving to comply with it, they're offering consent options that are, have multiple checkboxes. So you can contact me via email, you can contact me via text, you can send me advertisements about deals, you can send me notifications about my product or my order. Those are all different options. And if an individual only gives you consent to contact them by email about an order they made, then you can't text them. You can't use the same data that you got permission to use to text them about a 20% off or a buy one, get one. So even though they gave you permission, it doesn't mean you can use their data in other ways. And similarly, if you don't disclose that you're sharing data with third parties and they don't give you consent, then you may be restricted. Or if you've got a contract with a data subject, then you're restricted to the uses and transfers that are described in that contract. So when we're talking about data usage and third-party transfers, one of the issues that can come up is an organization thinks that it's got some freedom and discretion because it did have consent or contract to use data in a certain way. So it takes the same data and decides to sell it or to share it with a third party, or to use that data in a way that wasn't initially intended. And Facebook is the organization that's getting the most publicity and probably had the most flagrant example of a way that it got data permissibly from individuals, but then it used that data in ways that it didn't disclose, and knew that the individuals wouldn't give it permission to use that data for, and shared that data with third parties that shouldn't have received that information. So we're talking about security and privacy with respect to data usage and third parties. Security tends to go towards the tools that can ensure that the data is protected. That it's only accessed within certain safe manners or shared to third parties within certain safe manners. But privacy says it's not just about whether or not you use FTP or a secure method. It's whether or not you're even allowed to share that data with that third party, or whether you're even allowed to use that data in that way. Let's next talk about data minimization. In some ways, the next two components will have what I think is more alignment with the privacy and security concepts. From a data minimization perspective, security is typically concerned with the amount of data and how that impacts security risks. So, obviously, the more data that you have, the more exposure that you have, and the more types of sensitive data that you have, the more risk that you have. On the privacy side, it's not so much about risk; it's about the purpose for which the data is collected. So, it's on the privacy side, it should be that organizations are only collecting and sharing the amount of data that is the minimum necessary in order to perform a task. So, for example, if you're collecting an IP address, but you don't actually need an IP address to accomplish the task that you collected that data for, then you shouldn't be collecting it. If you're collecting age when you don't need age to sell a product or to provide a service, then you shouldn't be collecting age. If you're asking for location data or other types of personal data while you're performing a certain task, you should be asking yourself, is this data element necessary to perform the task, or can we still perform it even if we don't get it? And that's the takeaway here. I reference data mapping because I think that's a component that's useful for both privacy and security purposes. But what do we collect? Who do we get it from? What do we do with it? Who do we share it with? And is it absolutely necessary in order to perform the task that's collected for? And that's a way of identifying what you've got, what you need to protect, what you need to control, and then whether or not you have any excess data. So I think from a security and privacy perspective, the intent would be to get the least amount of data necessary. That may not be consistent with business goals, but from a security and privacy perspective, I think data minimization is a issue where they're aligned. Our final key component is about retention, and in this case, I think security and privacy would have total alignment. That data should be maintained for as short a time as possible. But there are cases where there might be tension between privacy and security, because on the privacy side, there may be a legal or contractual data retention minimums. And so the tension can exist not only from privacy that says you have to keep data for a certain period of time, and security says we want to get rid of it as soon as we can, but there's actually could be tension between different privacy requirements. And this goes back to that uniqueness or particularity concept that we talked about a few minutes ago. GDPR says that you should get rid of data. You should only maintain data as long as you need it. So basically get rid of it. There's no numeric data retention standard. There's no number of days, months, weeks, or years that you need to hold data in order to comply with GDPR. In fact, it's kind of the opposite. But there are other legal standards that require certain periods of time to maintain data for years, in fact. And so it might be challenging to meet both of those requirements at the same time. And that's why it's important to know which data privacy requirements apply to not just your company, but to certain data sets within an organization because you don't want to destroy data that you're supposed to maintain, and you don't want to maintain data that you're supposed to be destroying or returning as soon as possible. But from just a theoretical perspective, privacy and security should be aligned in terms of data retention, and that you want to maintain data for as short a time as possible. All right, now that we've talked through some of the key components, we want to talk about why it matters. We talked about why we're talking about it and some examples, but why does it matter that we know the difference between privacy and security? The first is that there's knowing the difference between privacy and security matters because, and this is not a joke, there are human lives at stake. This came from a U.S. cybersecurity website that said knowing the difference between privacy and security involves human lives. In our case, maybe a little bit less dramatic of a reason, but I thought it was interesting that at least one entity was saying this is life or death. For most of us, there are other reasons why knowing the difference between privacy and security matters. Knowing the difference between privacy and security matters because knowing why you do what you do matters. People within an organization are much more likely to buy in, support, and excel in efforts where they know why they're doing what they're doing. So privacy and security requirements are going to be met much more likely and maintained and excelled at if people know that there is a legal requirement from a contract, or if they know that there's a law, and not just that there's a law, but that the law has granted a fundamental right. And that's one of the things we try to do as an organization, is not just tell you what you're required to do, but why you're required to do it, because it's more likely to result in compliance when people know why. As we talked about a little bit earlier, data can be secure without being private. An organization can have strong physical security controls, strong logical access controls, strong risk management, application development, all of these different security requirements, training, background checks. But if it gives access to personal data, everyone within the organization, even in the midst of all those security controls, that data is not necessarily private. If everyone within the organization doesn't need access to that data, and so if people confuse the concepts of security and privacy, they might only achieve security. Third, everybody wants every security and privacy guarantee, but that's not necessary, and it's certainly not possible from sort of a practical, but certainly a financial perspective. And so whatever industry you're in, whoever you're doing business with, whatever your growth model is or approach, you'll probably have someone ask you for just about every type of information security or data privacy or regulatory compliance audit or evidence of compliance. And if you don't know the difference between security and privacy, you're not going to be in a good position to negotiate and have leverage when you're saying, no, we don't actually have to provide that to still be compliant. We don't have to implement that control. We don't have to undergo that audit. Those aren't necessary for us. Or from a business development perspective, it's important to know what you need, because then you can demonstrate compliance and say what we need are the following controls, the following types of compliance, and we have it. And you can be secure doing business with us. Fourth, underachieving compliance. If you don't know the difference between privacy and security, you might not know that you're subject to a certain law or a certain contract requirement, and it might be possible to achieve compliance if you knew about it. You just didn't know. And so if security and privacy are the same thing, and you don't know what privacy elements are really covering your organization, you might miss some. Then you might have overkill. You might have unnecessary efforts. You might have implemented something that you didn't need because you didn't know how to push back internally or to clients. You might have incorrect implementation. Just to go back to my example of when we talk about GDPR compliance, and organizations say, well, we have encryption, but encryption isn't a silver bullet to GDPR or to any other privacy law or a contractual requirement. So So it's important to know what the specifics are in order to meet those correctly. And then just in terms of trends and privacy requirements, it seems to me that there's an increase towards giving consumers and data subjects control over their data. That CCPA breach lawsuits, the right to action if there's a breach, gives a lot more control over personal data to data subjects. And then the trend towards monetization of personal data, not just an organization selling personal data to make money, but paying data subjects in order to get their personal data. And so, if you pay if you pay individuals to get their data, there's going to be more and more control given to the data subject. So these are some of the reasons that it's important to know the difference between data privacy and data security. Now, what happens when people know the difference? We get rainbows and unicorns, and relatively speaking, all is right with the world. Specifically, what does that mean? It means you get more business. Regulatory compliance and information security are business development tools. They're not just ways to prevent bad things from happening. They're ways to get more business. They're ways to reduce regulatory exposure. Some of the fines in individual data privacy laws are significant. GDPR fines could be up to 20 million euros. That's incredibly significant. And if you're covered by multiple privacy requirements, you could have exposure to multiple different financial or regulatory sanctions. It's a chance to reduce negative press when you know what you're supposed to disclose and what you're not supposed to disclose. You can avoid stories like what happened to Amazon in Germany not too long ago, when an individual based in Germany made a request under GDPR to access his history with Amazon. And he received not only his history, but he also received some voice recordings from someone who had an Alexa device. Only this individual didn't have one. So it wasn't his voice and it wasn't his data. And not only was it the voice of another single individual, it was the voice of two other individuals. It was a male and then what turned out to be his female companion. And this individual shared the data with a newspaper, and journalists were able to, based on the recordings of the voice and the things that were said, identify the individual who was on the recording. They didn't disclose his identity, but they were able to identify him and go contact him and confirm that it was in fact his voice recording. And so, from my perspective, that's an embarrassing story. And while that may not be the end of the world for Amazon, it might have a much bigger impact on a smaller organization who inappropriately discloses personal data, even in trying to be compliant. And then fourth and finally, just to gain a sense of certainty, your organization can move forward, not just performance tasks, but do so with a sense of assurance if it knows the difference between privacy and security. What are the requirements for privacy when it comes to access, and what are the requirements for security when it comes to access? What are the requirements for retention when it comes to security, and what are the requirements for retention when it comes to privacy? Moving forward, when both of those things are working together, privacy and security are working together, as opposed to in tension because there's a lack of information, a lack of resources, or a lack of concern, makes it much more difficult for your organization to have certainty. So those are the good things that happen when we know the difference between privacy and security. Before we get to questions, I just want to offer a brief explanation or description about how Kirkpatrick Price can help you with these privacy and security concerns. We are an information security firm, as I mentioned at the beginning, but we have data privacy services. Jenna mentioned some of those at the beginning of our webinar, and you can ask us questions about those services and go to our website for more information about those data privacy services. Not only do we offer those services, but we have personnel with the ability to simultaneously address security and privacy. We have highly qualified individuals who are able to navigate these concepts and aren't stuck separating the two and only giving you information on security or information on privacy, and making things more difficult for you in terms of application. Whereas in some cases you might get someone who's an expert in one, but they can't tell you how to navigate the needs of both privacy and security. And then we're able to provide services for global and custom privacy requirements. So things like GDPR and HIPAA and consumer financial protection laws, but we also work with clients who have a contract requirement or other unique or particular privacy requirement that's come out of a certain business opportunity, and we're able to craft a solution for them to address their privacy needs. So we'd love to be able to help you out in navigating your privacy and security needs. With that said, we can open it up to questions.
Great. Thank you so much, Mark. That was some great information. And we do already have a few questions, but continue to send them in, everybody. We're happy to answer them. Our first question is about AI, Mark. And this says, where data scientists want all data and kind of want to keep it forever, how do you foresee companies addressing the risk associated with this, and potentially could be a lucrative area of business?
Yeah, that's a good question. So you saw my bio briefly at the beginning of the webinar. My background is as an attorney. I'm an active member of the Florida Bar, and my bias and perspective is towards the regulatory compliance aspects of privacy. So I'll fully own that. I think there's going to be a tension there between what's useful from a research and scientific and business perspective, and what regulators are leaning towards, and if they're speaking accurately, what data subjects want as well, which is some restriction and some control. Things like AI, though, are going to be there's going to be a particular awareness of things like AI and smart cars and technology that's really on the cutting edge, where, for example, GDPR, if those scientists were subject to GDPR, they would probably have to perform a data protection impact assessment prior to engaging in the use of data, personal data for AI purposes, which basically goes through the process and says, do we have enough controls in place to appropriately reduce the risk to individuals if bad things happen from this data? And if you don't, you might have to go talk to a regulatory authority. And even in some cases, there may be some countries that have already put out white lists or blacklists that say AI is required to have a DPIA, and it may get to the point where they say you have to come talk to us and get approval for specific AI research or business functions. So that may be the way that the retention and access issues are addressed, is on sort of a case-by-case basis, or some sort of certification or code of conduct when it comes to AI. They don't exist yet, but GDPR is supposed to have those. And then other privacy requirements might follow suit. So I think we're kind of on the cutting edge of how to navigate that tension when it comes to AI. But I think it exists and it's real.
Great. Our next question is about PHI. Specifically within your own facility, is the standard that PHI is only disclosed to those directly involved in the patient's care or directly involved with billing and payment? I think what this person's trying to get at here, they give an example. Someone from business development or marketing asks for some reporting with raw data that includes PHI when they're working on like a marketing strategy. Is that allowed within your organization?
I would strongly discourage that kind of disclosure of AI with PHI within an organization. That's a good example of where it might be securely shared, but it wouldn't maintain the privacy standards that HIPAA expects. I don't think you can make the argument that someone from marketing can't perform their marketing tasks without that PHI.
Gotcha. We also had someone just make a comment about privacy enhancing technologies. I didn't know if you wanted to just make your own comment on those types of technologies, Mark.
I'd be curious to know what if they had some specifically specific privacy enhancing technologies in mind. I am aware of what I think it's been referred to as sort of data trusts, which are organizations that sort of become like a black box for privacy, to serve as the privacy controls for a total solution, where they say company provides, sort of like AWS is now for data storage and hosting services and things like that. But instead of just from a technology or security perspective, it's you give them all of your data and you let them perform all of the processes, because they'll be the ones that maintain privacy. So like a total solution where you just sort of become a pass-through entity, because they're saying we will be the ones to totally maintain privacy. I think that's an interesting concept, but I wonder how practical and feasible it is. I think we're on the cusp of that. I haven't seen anybody trustworthy really offer those kinds of services, but I think some of the larger companies that you probably would guess would have are the ones that are exploring the option to serve as data trusts, in an effort to alleviate the challenges of data privacy for organizations. Instead of trying to figure it out themselves, you just give it to them, pay them a fee, and they'll figure out all the challenges for you.
Gotcha. Those are all the questions that we have for today. Obviously, a few people have asked if the slide deck will be available, and of course, you guys will get that tomorrow in your inbox, as well as a recording of this presentation. We'll also include just some relevant resources. A couple of you have asked for some more expansive privacy resources, so we'll include those as well. Thank you so much, Mark. This has been a great hour. And everyone, if you're interested in our next session, it will be still regarding privacy. Our registration will be up soon. That one takes place in about a month, so be on the lookout for that as well. Have a great rest of your day.